Gosh, you actually got quiet and silent before the lecture. Can't be anything interesting on Facebook this time, huh? Nothing to say other than things are going well, I hope. And I'm having a few problems with one or two of the seminar groups. Not because of anything else, but I think maybe you're just coming out of holiday mode. So not much work has been done, I guess. But I want to urge you to actually get down to work now. I mean, you're at second semester. And some of you haven't yet done an analysis and an opinion. You really need to do it. If the first analysis you're going to do of a bond fact pattern is at the exam, I'm not sure you're going to do it terribly well. So do try to come in and participate. It's really, really important. Because this is not what the module is about, this lecture. This is just me throwing knowledge at you. You need to be able, when you step out, to have done a module which actually trains you to think and write like a practitioner. That's the whole purpose of these modules. And you're not going to do it unless you actually get around to doing the practice sessions I give you, which we look at seminars. Right, okay, let me get this thing off the ground. Oh, darn, sorry, wrong USB stick. Let me try another one. Oh, wrong one again. I'll get to it, sorry. There's so many of this stuff, all having very similar titles. Okay, we're there. We were looking at the structure of the bond instrument and the terms and conditions in the bond instrument, if I remember correctly. We walked through the basic provisions relating to payment of interest and the like, and the different types of clauses you'd expect to see. Yeah. Looked at different formulations of these clauses for payment of interest, for payment of principal. We looked at things like early redemption provisions relating to purchase funds and similar. We looked at withholding tax clauses. We looked at the negative pledge. Did I look at that? Negative pledge clauses and stuff? I did, right? I did. Yes? No? And pari passu covenant, I took you through that. The Argentina rescheduling problem in relation to the standard pari passu clause. Yeah? Okay, good. And then I'm going to look at today, and I think I mentioned this bit, that there are many covenants which you come across in syndicated loans which are not found in bond issues, in particular the financial ratio covenants, which are found only in high-yield bonds, which is a separate topic, and I will come to that later. But things like the asset disposal covenant, the merger control covenant are not used. And I think we also looked at the issue of why is it that covenant protection is not as strong for bond investors when compared with syndicate banks in a syndicated loan. We looked at what are the factors driving this. And I think the bottom line that we came to is that the covenant protection that investment banks will include in the bond instrument will be just sufficient to entice investors, induce investors to come and buy the bond. Anything lower, and the bond investors will not buy. Therefore, I think it's the expertise of the investment banks to actually come up with exactly that right level of covenant protection, which will enable bond investors to buy without shunning the bond because it doesn't have the right level of protection for investors. So those are the covenants, terms and conditions of the bond. I'm now going to get on to events of default contained in international bonds. I mean, many of them you're going to be totally familiar with, but let's go through them anyway. The first one, the obvious one, failure by the issuer to pay interest and or principal when it is due, on the due date, by the due date. Secondly, any breach of obligation of any covenant, which we've just talked through, all those covenants, any breach, and that's an event of default, as expected, just like in a syndicated loan. There is then a provision which you probably haven't come across in international syndicated loans, but which is one that's common in international bonds, and that is the imposition of a moratorium under applicable law. Note that phrase, under applicable law. It's not any old moratorium imposed anywhere on the planet which affects the issuer's ability to pay interest or principal, but a moratorium imposed under applicable law. And you know what that analysis is all about. Applicable law has got to be determined by reference to what is the governing law, and the governing law will decide what is applicable law, and therefore which moratoria are applicable and which aren't. And you know where that leads to, don't you? All right, wake up and think. Anybody in a wine haze, take a sip of water and think. What are you at when you say a moratorium under applicable law and you're applying the governing law in a standard bond instrument? What do you get? Sorry? Okay, that's the governing law, but when you apply the phrase applicable law under the governing law, what do you get in relation to a moratorium? What is applicable? Sorry? Law of the seller. Louder, please. Can I hear? I can't hear you. Why is the place of performance relevant? Moratorium under applicable law. It's a lot late in the day that you can't give me a straight one-line answer, which means you don't really have an understanding of this subject under syndicated loans. It's the same principle, absolutely the same principle. How do you determine what is applicable law under the governing law of a loan agreement, or indeed here in a bond issue? We've looked at this problem, exactly the same problem under syndicated loans, and you very neatly copied it all down, because this phrase appears in the LMA agreement. And we talked about it at length. And that's why I keep saying you don't think, you have the same thing coming up in a different context, and you are still at sea. So could you just give it a bit of thought? Try to get your mind to harness what you know, or turn the page on your notes and find it. It's not going to happen, is it? Okay. How do you know which moratorium is applicable? How do you know whether it applies in a syndicated loan? Rome 1, thank you. So how do you do it here? Thank you. Start with the governing law. Right. Where do you go next? Not Article 9.3. Can you please remember, Rome 1 starts with Article 3. There's going to be a huge pile of red gap marks in your exam paper if you jump to Article 9.3. Article 9.3 is not what says that you will look at nothing other than the governing law. It's Article 3. So if you're looking at what is the applicable law that you're going to look at in relation to a moratorium, governing law dictates it. If the governing law is English law, Rome 1 will dictate it. Rome 1 says nothing but the governing law, unless Article 9.3 enables the application of the law of the place of performance. This is the same old analysis that we've gone through 100 times at lectures, at seminars, and so, yeah, the moratorium under applicable law, the moratorium under the place of the issuer's incorporation becomes irrelevant. Remember? Oh, it's all gone into Christmas puddings and Christmas turkeys and ski resorts and Koh Samui and wherever else it's gone. Okay, so that's something you need to remember, that it is an event of default, moratoria under applicable law, but when you look at the guts of that clause, that phrase applicable law means that you've got the same problem you had under the LMA illegal to lend clause. Because all that happens is that the Rome 1 rules come back into play. It's not any old law, it's applicable law, and governing law determines that. Governing law English, if it is, then the Rome 1 rules kick in. All right, let's move on and let you think about it, because I keep on repeating myself lecture after lecture. You cannot do this module unless you're on top of what has gone before. See, I mean, otherwise I'm repeating myself over and over again, as with moratoria under applicable law. I'm going through the same stuff I told you at lectures, at seminars, I'm doing it again. Anyway, okay, here we are. Next one down, insolvency of the issuer. The clause relating to insolvency is exactly the same as in syndicated loans. I'm not going to ask you what is it, because I bet you nobody here can tell me what it is, so go back and read your notes. It's the same thing, the same insolvency clause, because it doesn't refer just to technical insolvency and liquidation. It is any insolvency proceeding under applicable law, applicable to the issuer. We've then got something that's an obvious one, withdrawal of any consents or changes in, once again, applicable regulation. And this clause would really be triggered in relation to withdrawal of exchange control permissions, the right of an issuer to carry on any particular kind of business. In other words, this is the regulatory side. If those regulatory consents are withdrawn, again, insofar as the regulations are under applicable law, then that's an event of default. But once again, remember, it's applicable law, applicable regulation. Next, something we've talked about, downgrade by rating agencies. Again, this is a clause which is now used in syndicated loan agreement. I talked about it in detail when we were talking about default provisions in syndicated loans. Downgrade by rating agencies, meaning ordinarily it's a two-level downgrade of the issuer's publicly traded debt. In other words, it's other bonds if they are being traded, or this bond if this bond is being downgraded by a rating agency by 2 levels or 2 notches, you've got a default. And then you've got the cross-default clause. Once again, the cross-default clause is not a generic one. You need to look at what is the specific language of a cross-default to work out how does it work. Now, in a bond issue, a cross-default clause is much more loose, much less stringent than in a syndicated loan. If you remember, the syndicated loans cross-default clause takes one of 2 forms. The stringent version, which refers to both a default under any other loan agreement, financing agreement, etc., and an event which, by the lapse of time or otherwise, may become an event of default, i.e., any breach of covenant. That's the strict form. The more relaxed form is if there is a default under any other loan agreement, any other financing arrangement, any other financial transaction document. And it's that form that you find invariably being used in bond documentation. You do not see the very stringent form that you sometimes see in syndicated loan agreements. And one other thing, if you remember the syndicated loans cross-default clause, and I'm not going to ask you the question because you will never answer it, the cross-default clause refers to any default or any potential default capable of becoming an event of default in relation to borrowings, indebtedness, or any other financial arrangement or transaction. So extremely wide. It applies to any kind of borrowing, any kind of indebtedness, any kind of financial transaction, including, for example, a derivative transaction. That is not the case in relation to the cross-default clause in bond issues. The cross-default clause in bond issues in market practice relates to a default occurring in relation to either indebtedness or bank borrowings or public indebtedness. The latter one, public indebtedness, is the formula more commonly used. And public indebtedness means any debt which is actually on a public exchange. It's public. And that means any other bond issue. So any other bond of the issuer goes into default, this bond gets triggered. How many of you are awake for me to ask you a question? Why do you think this is? Why do you think bond investors are getting a cross-default clause which is really quite weak? Okay, let me put a question the other way. Okay, sorry, anybody else wants to say anything? Any views? All right, let me put a question to you. You are an investor in a bond which has got a cross-default clause. You become aware of, due to a public declaration, that your issuer is in negotiations with its syndicate banks for breach of covenant. Any thoughts? Do you have to worry about the width and breadth and length of your cross-default clause? You don't think you've forgotten completely, haven't you? All of this stuff. Okay, let me give you the answer, but it's going to be pointless because this is the kind of thing that comes up in exams and you'll be clueless again. You see, if you are a bond investor with a cross-default clause in a bond, insofar as it refers to a default occurring under any loan arrangement, loan agreement, or public indebtedness, if that wide phrase, it means that if anything happens under an SLA, that default will trigger a cross default in the bond issue. Now you can see how effective even a weak cross default is, because if there is a very powerful set of financial ratio covenants in an SLA and one of them is breached, giving rise to an event of default under the SLA, guess what happens under the bond instrument? There's a cross default occurring. Okay, go away and think about it, because I can see blank faces because you don't know how the cross default clause works. A default clause and a cross default clause works in a syndicated loan. Okay, I'm going to repeat this one again. If you're not on top of what I've said last semester and what we did last semester, you're going to just sink this semester. Utterly sink. So please get on top of it. I said this to you guys before you went away on holiday, because I knew I'm going to have to talk about these things when you came back. And I can't repeat the lectures I did last semester, okay? So anyway, the reason why the cross default is less strict is, as someone pointed out here, it's because the investment banks will have a cross default clause which is just sufficient to enable investors to feel comfortable. Investors do feel comfortable because they know as long as the cross default clause locks in to default clauses in SLAs, they're home and dry. Because those SLAs have the most stringent covenants, including financial ratio covenants. Therefore, if there is any breach of those covenants, it constitutes an event of default under the SLA. That locks into the cross default clause in the bond. Okay, go away and think about it, because you're lost. Yeah, go ahead.
I understand that this cross default, it's about time. So SLA triggers, SLA cross default triggers, and then if that one triggers the bond.
Exactly right.
So I'm late.
Yes, you are absolutely right. You won't be the first person to be at the starting blocks of negotiation with it'll be the syndicate banks. And the syndicate banks may not call default. They might leave the breach as it is and start negotiations with a borrower, which means as bond investors, there's nothing you can do. You're absolutely right. There is a time gap between what happens under an SLA and what happens in a bond. Absolutely right. Okay, moving on. Those are the events of default. Now comes the question of how do you call a default? Now, the default mechanisms in an SLA, you know what they are. Syndicate banks buy a majority by reference to whatever the percentage is that has been specified of loan outstandings can call a default. In international bonds, there are actually two different structures, alternative structures used to enable the calling of default. The first one is the trustee format, where a trust deed begins to operate, which is signed when, just to remind yourself? Phew. God, no, not at launch. Go, have another go at it. Another dart, let's go, see whether we get it right this time. Definitely not launch. Somebody said something. Yeah, it is closing day. The trust deed would be signed if it is being signed on closing day. When a trustee is appointed and the trustee is given powers to call a default. In international bond issues, that is a minority of bond issues which are subject to a trust deed, for obvious reasons. Bond investors across the globe aren't familiar with this strange creature called a trustee under common law. We'll come to how this works shortly. But the more common format, accounting for about 60 to 65% of international bond issues, is something called a fiscal agency agreement, where a fiscal agent is appointed. But very importantly, this entity appointed as a fiscal agent has nothing to do with the calling of default. Repeat, nothing to do with the calling of default. What the fiscal agency agreement contains, however, is a procedure for the calling of default under a mechanism called a collective action clause, a CAC or CAC. The collective action clause requires a majority of bondholders as defined. Bondholders as defined, where in the bond instrument and the fiscal agency agreement, to elect, to vote to call a default. There is no trustee, and there's nobody else other than the bondholders as defined who are required to pass a resolution to call a default on the occurrence of an event of default, if they so wish, by the appropriate majority of bondholders voting. Now, it's very important to understand who is a bondholder in the context of the CAC clause in international bond issues. A bondholder is always defined to mean the holder of the physical bond, meaning the permanent global bond, and account holders in the clearance systems. They are the only entities which can call a default. And usually the standard level of CAC majority voting is there must be a 2/3 majority of all bonds outstanding in order for the calling of default. 2/3 majority of all bondholders by reference to their bond, lack of a better word, holdings. They are the ones who are entitled to call a default. Just by way of comment on something that we've been talking about at seminars very recently, incentive payments. In SLAs, we talked about incentive payments being made to syndicate banks. The same thing occurred in relation to bond issues where bondholders, i.e. the accountants of the clearance systems, were offered incentives, premiums, to vote in favor of a resolution, to modify the terms of how default would be called. And it went to a court, the High Court, and they in relation to a Brazilian issuer. And the court held that it was perfectly acceptable to offer inducements to influence the way account holders, bondholders were voting. So that's just a by-the-way comment because we were talking about it at seminars. Now, that's the 2/3 majority for the calling of a default. And that also means that in relation to other events contained in the bond instrument, such as a restructuring, a similar 2/3 majority is required by bondholders. And restructuring is defined to cover the following items: any postponement of the maturity date of the bonds, any reduction of the interest rate payable on the bond, any reduction of the principal amount payable on the bonds, cancellation of interest payable, cancellation of principal payment, changing of the currency of the bond, and sometimes it covers also changing the major covenants in the bond instrument or to the place of payment of the bond. That will require a 2/3 majority of bond investors to vote, I should say bondholders, to vote to change and amend the bond instrument in relation to any of these things. Now, there is in the market a model collective action clause, which is promulgated, published by ICMA, the International Capital Markets Association. But this model CAC is only for bonds issued under English law. And if you adopt the ICMA format, which is the market standard format, that requires not 2/3 majority of bondholders, but 75% of bondholders to approve anything that's classified as quote unquote under the clause a reserved matter. And reserve matter includes changes of interest payable, changes of principal payable, the dates on which the interest or principal becomes payable, and changes to the place of payment and the dates of payment. All of that will require, and if you use the ICMA model CAC clause, 75% of bondholders. Yeah, more on this one. For other matters, i.e. those other than what are reserved matters, in other words, non-reserved matters, all other resolutions would require a 2/3 majority, including for purposes of calling default. So to that extent, it's the same as market standard CAC clauses. The ICMA CAC also requires the 2/3 majority of bondholders to call a default. But one thing requires 100% vote, and that is to change the governing law of the bond instrument. You can't change the governing law unless all bondholders approve, and the reason is obvious. The moment you change the governing law, the entire framework, structure, architecture of the rights and obligations changes radically. And therefore, quite rightly, the ICMA clause requires 100% approval of bondholders. Now, there's a third type of CAC that's found in the market, and that's a CAC which was promulgated under the ESM treaty, the EU's ESM treaty. The ESM stands, European Stability Mechanism, established in January 2013 in the context of the Greek crisis. The ESM CAC clause, now called the Eurozone CAC clause, should be used for all EU sovereign bond issues. And the formula in the Eurozone CAC clause is that in relation to reserve matters, there must be a minimum 2/3 majority of bondholders. All reserve matters, which were pretty much the same as this lot. You need a 2/3 majority. That includes for restructuring purposes. For non-reserved matters, including the calling of default, all you need is a 50% majority. Now, it is important to understand that the Eurozone CAC clause percentages are minimum required for Eurozone EU sovereign bonds under the ESM treaty. They are minimum. So if, for example, you got an English law-driven bond issue by a Eurozone sovereign state, example, Portugal or Greece or Italy, then you've got an option. You can either use the Eurozone CAC under the ESM treaty, or you can use the ICMA model CAC for bond issues under English law, because the percentages required under the ISMA model CAC are a lot higher than the Eurozone CAC minimum standards. So there's an option. But the important point is, as far as Eurozone sovereign bond issues are concerned, that is your minimum. You cannot have anything other than a CAC which has got these minimum voting resolution requirements. Clear? Yeah.
Is it the fiscal agent, the one that proposes the resolution?
No. Like I said, the fiscal agent has absolutely nothing to do with the calling of default. Zero. So why the hell is it included in the fiscal agency agreement? Good question. I understand that entirely. The reason is historical, as usual. The fiscal agent, as the name might somehow suggest it to you, is a form of paying agent, making transfers, like an agent in a syndicated loan, somebody through whom payments can be made by the issuer to the bondholders. Because of that function, they included, in the old days, old days meaning 25 years ago, the voting procedures available to bondholders by way of collective action procedure as an appendix to the fiscal agency agreement. That practice has continued even though paying agents are now virtually not used in practice. So what you really need in a modern context is a document which sets out default provisions under collective action clause procedures. Now, these are, don't forget, these are also included in the bond instrument, because just like the covenants, the default provisions and the cross-default provisions are included in the bond instrument. Where do you find the bond instrument? Answer, just so that you remember this, in the back of the subscription agreement as an appendix.
Would this even apply if there was a trustee format?
No, you would never have a collective action clause procedure for the calling of default if there's a trustee. And there never is a fiscal agency agreement if there's a trustee. They are mutually exclusive, because the trustee structure is quite different, very different from the process for calling of default under collective action clause, CAC procedure. Anything else you guys want to ask? Okay, now what happens under a trust deed structure? Now I'm going to look only at an English law governed trust deed, because that's what the markets use. There is, however, a New York law governed trust deed which is called a trust indenture. By the way, trust indenture is a 19th century English word for trust deed, but being good old Americans, they insist on using Old English. So they use a trust indenture, but the important thing about this trust indenture is that it is heavily regulated under the Trust Indenture Act of 1939, the US Trust Indenture Act of 1939. So why am I not talking about it? Because all international bond issues fall within an exemption to the Trust Indenture Act 1939, which I will come to when I talk about United States regulation of global markets. Consequently, New York law controlled trust indentures are not found in practice in the markets. What you do find if you're using a trust deed is this English law controlled trust deed. Now, the key point about the trust deed structure and the appointment of a trustee under the trust deed is this, that under the terms of the trust deed and the terms of a bond instrument, only the trustee has a power to call a default when an event of default occurs, nobody else. Importantly, it's a power to call a default. It is not a duty to call a default. The trustee is under no duty to call a default on the occurrence of an event of default. It's a power which it can exercise or not exercise as the trustee chooses. Secondly, only a trustee having called a default can accelerate the bonds. Now, you know the difference between the calling of default and acceleration. Exactly the same as in a syndicated loan. The calling of default does not automatically result in acceleration. There has got to be a decision by the trustee in a bond issue and a syndicate majority syndicated loan to actually make a demand for all outstanding payments. That is acceleration. On the trust deed structure in a bond issue, only the trustee can call for immediate payment of all outstandings, even if the trustee has decided to exercise its power to call a default. Thirdly, only the trustee can initiate legal proceedings to enforce a bond if the issuer, having defaulted and the trustee having having used its powers to accelerate the bond, fails to pay. At that point, only the trustee can exercise these powers to take court proceedings and enforce the bond instrument. This is called the no action clause. Bondholders are barred very important, are barred by a specific clause in the trust deed and the bond instrument from A, calling default, B, accelerating the bonds once default is called, and C, taking any enforcement action. They're barred, prohibited. Only the trustee can do any of these things. And that's important to remember, that this is why the structural separation between a trust deed structure on the one side and a CAC structure on the other. Like I said, it's a minority of bonds which are subject to trust deed structures, roughly around 30%. But it is important to understand this, because then the next question that you've got to look at is, well, what if the trustee just doesn't do anything at all? Well, there is a backup. Trustee can be compelled by an extraordinary general resolution of 2/3 of the majority of bondholders, 2/3 again, to exercise its powers, to call a default or otherwise. It, therefore, the bondholders can't do anything, can only instruct the trustee to take action. It's a power to compel the trustee to take action. Now, given this structure, the one question that obviously must come to your mind is, why should a trustee be appointed? I'll come to the commercial and practical reasons why a trustee is appointed. And most law firms will recommend the appointment of a trustee in practice. But there is no specific legal requirement, either under English law, if it's an English law governed bond instrument, or under applicable EU regulation, to appoint a trustee in relation to a bond issue. That is not the case if you're choosing New York law, because the US Trust Indenture Act 1939 requires mandatory appointment of a trustee unless, important one, unless an exemption applies under the Securities Act 1933. And in practice, all international bond issues are done within the exemptions to the Trust Indenture Act 1939 of the US, so that the Trust Indenture Act mandatory requirement to appoint a trustee does not apply. And secondly, more importantly, even if a trustee is appointed because people have taken a decision to appoint a trustee for commercial reasons, the detailed provisions of the trust indenture contained in the Trust Indenture Act of 1939 need not be complied with. Why? Because the Trust Indenture Act is disapplied in relation to international bond issues because of a specific exemption contained in US regulatory law, which I will come to. Are you kind of on board up to now? Yeah? We're slowly slipping into the applicability of US regulatory law. It's touching us now, but soon we'll have to start getting slapped by it. So, now, the one question that I think I probably should explain is, what is the relationship between the trust deed, when it is used, and the bond instrument? The fundamental point is that the bond instrument is subject to the terms of the trust deed. The trust deed overrides. The terms of the bond instrument are also, however, contained in the trust deed itself. You then need to understand exactly how this trust thing works. In particular, exactly what is the trust? What are the assets that are subject to the trust? Well, let's start with some basics. A trustee in the common law is not a fiduciary agent, as some civil lawyers assume it to be. Not at all. It is not a fiduciary agent because it, and it alone, has legal title to trust assets, nobody else. And it is subject to duties on the basis of the fact that it is the owner of assets, the trust assets. But importantly, the legal title to those assets has to be separated from the beneficial interest or the beneficial title to the assets. The trustee remains the legal owner of whatever the asset is, and I'll talk about it in a minute. Whereas somebody else happens to be the beneficial owner of the assets. That's the starting point of understanding this structure. What you then have to say is exactly what is the trust asset, how is it created, and so on. The easy answer on how is it created is very simple. It's in the trust deed. The trust deed creates a trust, appoints a trustee in relation to the bond issue. Next question, the far more important question is, what are the trust assets? Many people in the markets, including lawyers in major law firms, imagine that the bonds are subject to the trust deed. And the straight, clean, clear-cut answer is no, the bonds are not subject to the trust. They're not the trust assets. Something else is the trust asset. And if you read a trust deed and a bond instrument where a trust deed is issued, you will see quite clearly that the trust asset over which there is a trust and over which the trustee has control shows in action the right to interest and principal payable under the bonds, but not the bonds themselves. It's a right to interest and principal. Now, this raises an interesting question. If the trustee has the trust asset, namely the right to interest and principal on the bonds, what rights do the bondholders have? Well, here you come across what we call the parallel debt structure. In the bond instrument, the issuer promises to pay bondholders interest on due dates and principal when the bonds are being redeemed. Promise one, debt one. In the trust deed, the issuer promises to pay the trustee that very same interest and that very same principal repayment. That's why it's a parallel debt structure. But the trust deed provision then goes on to say, insofar as the issuer pays the bondholders interest and principal, then its obligations to the bondholders as well as the trustee are satisfied pro tanto. That's the parallel debt structure. So while you've got two debts, only one payment, quite rightly, practically speaking, is required, and that is to the bondholders. So, in effect, the parallel debt structure means that as long as the issuer is continuing to pay interest and principal to the bondholders, the trustee lies dormant. Its right to payment in interest and principal is satisfied insofar as the issuer pays the bondholders. But when you go back to the default provisions, you can see what happens. The moment the issuer fails to make an interest payment, fails to make a principal payment, something happens. An event of default occurs, and the power to call a default shifts immediately into the hands of the trustee. After that, only the trustee can act. Only the trustee can call a default. Only the trustee can accelerate bonds. And then the bondholders are suppressed and become dormant. And that's how the structure works. Any questions? Yeah.
Just wonder, where is the trustee or fiscal agency in the bond structure clause?
Go slow, please, and speak up.
Where is the trustee or the fiscal agency in the bond structure? Because we can't find it according to the previous diagram. I tier 4 buy bond from tier 3, from tier 2, from the account holders, but I can see the...
If you're a tier 2 entity or a tier 3 entity in your diagram, you're not a bondholder. Bondholder, remember, is defined in the bond instrument, in the fiscal agency agreement, to say bondholders are only and only the account holders in the clearance systems plus the person or entity holding the actual physical permanent global bond. As a tier 2, tier 3, tier 4, tier 5 investor, you are not a bondholder. Clear? Sorry? You can certainly instruct up the chain, as we discussed when we were talking about the structure that we've got in the markets. You certainly can, but what you can't do is to have direct access, whether under the collective action clause procedures or under the override powers contained in a trust deed where bondholders can override the trustee exercise of power. You cannot directly do that. Anything else? Yeah, please do.
So why would you like global opinions advise to use this trustee?
Could I come to that shortly? I think there are very good reasons why most of us would say, please do consider a trust structure. In particular, just think of it this way. Supposing there's a problem with regard to the issuer paying interest on principal. Supposing there's a problem with the issuer in relation to the negative pledge clause. Now, what happens now? If you've got a CAC clause, a collective action clause, CAC clause, bondholders must act, must organize a majority to decide something. But more importantly, somebody has got to negotiate with the issuer. How many bondholders are going to get involved in the negotiations? And if one proposal is ditched, refused by the issuer, what happens next? Back to another collective action clause resolution, another proposal, and over to the issuer. That's a very cumbersome and slow process. You've got a trustee, the trustee steps in on behalf of all of the bondholders. All bondholders can now no longer take action. It will negotiate directly. Let me come to these details later. I haven't yet looked at this commercial issue of why do we want to appoint a trustee. Yeah. Why is what? I didn't say that. Let me go back. You're not, if you look at what I said earlier, I'm going to put it on the board so you know that I said it. Look at the last bullet point. Look at the point again. People don't draft these things in that mishmash, broad brush way. There's a reason why I use the phrase not a fiduciary agent. So what is being said is that it's not a fiduciary agent. Whether it has a fiduciary relationship is a totally different issue, which I will come to shortly. Okay. So, hang on. Now, the problem, hang on, I shouldn't use the word problem. One of the issues that arises is you can appoint a trustee under English law for purposes of international bonds. The next question is, what happens when the trustee has got to work in France, Italy, or a Brazilian issuer, or a Russian issuer? Where are we? What happens? This time you don't have Rome 1. Because if you remember, Rome 1 doesn't affect trustees. Consequently, something else has got to be done. The matter actually did come up in France and before the French Supreme Court in 2011. There was an international bond trustee who needed to take action. The trustee was appointed under New York law trustee with the same identical parallel debt structure that you find in the international markets. And the French court said, yes, this entity may act in relation to this entity called Belvedere in 2011, even though French law did not have trusts incorporated. This was a recognition decision, i.e., the French Supreme Court said French law would recognize the nature and functions of an international bond trustee, including the parallel debt structure to be found in the New York trustee. But that's just France. German courts have refused to recognize trustees because, according to the German courts, trusts are incompatible with German law. And the case is up there for those of you who are German lawyers who want to go look it up. The German Federal Court of Justice in what we call the Praxis decision in 1985 said, sorry, not going to recognize trustees. So that leaves quite a big problem for issuers wanting to use international bond trustees to manage their issue. The solution was, no, I shouldn't use the word solution. A possible solution is to be found in a Hague Convention on Trusts, drafted in final form in 1985, effective 1991, which requires all signatories to recognize the common law trust. Note, just recognize, not to import it, not to incorporate it into their law systems, simply that they will recognize a common law trust. And I think about 14 countries to date have signed it. And the countries up there, France, Italy, Switzerland, Netherlands, Monaco, Malta, Luxembourg, and China, most importantly. But a lot of other countries who should be thinking about it have not signed up to it. Germany in particular, Spain, Japan, Russia, Brazil, Mexico, they haven't. Needless to say, all the common law countries have easily signed up to it. So the convention is there, and the more countries who sign, the more effective the process will be in terms of recognition. Okay, so that's the position with regard to trustees. I'm now going to get on to trustees' duties and powers. But let me, before I go in there, let me just stop and ask people whether you've got any questions so far. Yeah.
Which state trustee or the institutional state the bond structure, just under the or from the beginning of the bond issue.
What happens at the beginning of the bond issue? Sorry.
I mean, you know, well, the trustee or the institutional, to which states they will stay in the structure, only in the default or from the paying, they are the part of the documentation.
Okay. Backtrack a bit. A bond issue, an international bond issue, will either have a trustee and a trust deed structure, or a fiscal agency deed, a fiscal agency agreement, and a CAC structure. They are never used at the same time. Point one. Next question. When is either, repeat, either the fiscal agency agreement or the trust deed signed? Answer, on closing date. So from closing date onwards, the structure is in place. But that is not to say that whether you're using a fiscal agent or a trustee isn't decided long before that. If you just give it a sit back and say, when do you think it'll be decided? When? Yeah. Term sheet. That's how far back it goes. And that's why I keep saying you need to understand the process. You can't read about the process and chuck it aside, because a lot of things lock into this process. So by the time of the term sheet and the mandate, whether a trustee is to be appointed or a fiscal agency agreement with a CAC format is to be used is decided in the term sheet. When the mandate is granted, is based on that structure. Obviously, it's not quote-unquote legally binding, at least if it's common law, but it becomes signed on signing date, and then it becomes legally binding. Yeah? Okay. Yeah. Why is it a... Why is it a deed and not an agreement? Well, firstly, because the trustee is appointed in relation to proprietary rights, property rights. Not that you can't do that in a contract, of course you can. But it's one of the elements of a deed that you're dealing with proprietary rights. And secondly, more importantly, there aren't, in fact, two parties agreeing to anything in a trust deed. In a contract, there are always two or more parties. In a trust deed, well, there are. Consequently, the terminology is to refer to it as a deed because there aren't two parties agreeing in a document called a contract. That's a trust deed. Nope. Nope. I know this should be under seal, stamped by a notary, all of that stuff. Not under English law. It's pure flexibility and informality. Yeah.
So, if we have trustee under this trustee, and this issuer goes in default, but gives a paper to this trustee.
Gives a paper.
Paper, something kind of, I will give all my derivatives as we had in our.
Okay, I'll come to trustee's fiduciary position very shortly. You can hang on. What I want to do next is to look at a trustee's duties and powers, and I'll talk about what you want to discuss in that context. Now, in legal theory, I shouldn't say legal theory because it's in real law. In all areas other than international bonds and international finance, when trustees are used, when trustees are appointed, they are subject to extremely strict and detailed duties imposed by the law and enforced by the courts. That's the starting point. But an international bond trustee under an English law bond trust deed is a completely different animal, even though it is called a trustee under a trust deed. The main reason why one says it's a different animal is that this trustee has either no duties or very, very minute few duties under the terms of the trust deed, if it's under English law. The trustee functions entirely on the basis of legal powers given to it in the trust deed. No legal duties. The legal duties which would otherwise be imposed by law under any common law system, and certainly under English law, are abrogated, eliminated, one by one, in the trust deed by express clauses. And I'll come to that in detail shortly, but that's a fundamental feature in relation to the duties and powers of an international bond trustee. Now, that's not the case with New York law-controlled trust indentures. If the Trust Indenture Act applies, and a trustee must comply with the applicable regulations of the Trust Indenture Act 1939 in the US, that contains a whole range of duties, which are essentially a mirror of the old common law duties in relation to trustees, but they are codified in the Trust Indenture Act of 1939. But remember, the reason I mention it only in passing is that international bond trust deeds are not subject to the Trust Indenture Act 1939 because of an applicable exemption, which I'll come to shortly. Okay, the second important point, general point, about a trust deed is that not only does a trustee function under a range of powers with few or no duties, in the exercise of the powers conferred upon the trustee, the trust deed confers sole and absolute discretion to the trustee in relation to the exercise of its powers. In other words, the ability to challenge a trustee's exercise of powers is reduced to near zero. I say near zero because there are issues under trust law which I'll come to later. But generally speaking, they can't be challenged because they are powers which are exercisable in the sole and absolute discretion of the trustee, quote, unquote, from a trustee. Okay, so that's the basic. Then you have powers of the trustee which directly have mirror duties, not on the trustee, but on the issuer. And the most important one is the information covenant. First of all, the issuer needs to provide the trustee with all information, financial reports, and other corporate or sovereign state reports which are made public. Remember the words made public. It's not everything, it's just those which are going to be made public. Must be given to the trustee, but that's not the really important power. The important power is the trustee's power under the trust deed to call for any information which the trustee in its sole discretion decides is relevant and material. And pursuant to that power, it has a power, an allied power, to ask to see the books of the issuer and the accounts of the issuer at any time. That's a very, very important power because it enables a trustee, if it wants, to go check what the heck is going on with the issuer. Secondly, if there is a default, the issuer comes under an immediate obligation to give notice of an event or default to the trustee. Failure creates another default, as you know from syndicated loans. And unlike in syndicated loans, in a bond issue subject to a trust deed, a no default certificate must be issued by the issuer soon after the annual results of that issuer are published. So it's an automatic legal obligation which kicks in. These are all, remember, all obligations owed to the trustee, not to the bondholders. Owed to the trustee. There's also an obligation on the part of the issuer, owed to the trustee, to maintain the listing of the bonds on the stock exchange on which the bonds were listed. So those are the three core elements of the obligations owed by the issuer to the trustee. And most importantly, the information covenant. Then you've got provisions in the trust deed relating to the trustee's powers. You know it has the power to call a default, which we've talked about earlier. It is a power to call for information. But then there are these very special powers. It's given a power to alter the trust deed itself. In other words, the very document which appoints the trustee and confers its power can be amended by the trustee and its sole and absolute discretion. It's not as crazy as it sounds because in the grant of this power to the trustee to amend the trust deed, there are absolute limitations, i.e. things the trustee cannot do. And those include altering the date of the interest payments, postponing the maturity date of the bonds, reducing or cancelling interest payable, or reducing or cancelling the principal payable. Those cannot be touched by the trustee in the exercise of its powers to amend the trust deed. The next category of no, you can't do this is a general qualification to the trustee's power to amend the trust deed, which says you will not make any modification to the trust deed or the bond instrument which are materially prejudicial to the interest of the bondholders. Now, it is as wide as that. There is no quantification. no specification as to what constitutes materially prejudicial. Reason is that what is materially prejudicial is a matter for the decision of the trustee in its sole and absolute decision-making power. So what is materially prejudicial to the interests of the bondholders is something which has to be determined by the trustee. And once it decides that something is not material, then it can proceed. But what is important is that it is a limitation, and a trustee cannot simply behave in a completely arbitrary, random manner and say, yeah, I'm going to do this and I'm going to do that. And these are the areas in which the materially prejudicial formula becomes relevant. Assume the trustee wants to change the pari passu clause. Assume the trustee wants to change the negative pledge clause, changes to the withholding tax clause, changes to the cross default clause. The powers of bondholders to override the trustee by way of extraordinary general resolution, change the listing of the bonds. All of those things would be cases where most law firms would advise that these would be materially prejudicial to the interests of bondholders, and a trustee should not engage in changing any of these things under the power to modify the trust deed. But that's simply legal opinion. It's not there in the trust deed. The reason why the trustee is protected, even though law firms can advise and say, well, don't do this because you're going to running a risk, is because of this conclusive determination clause, i.e., one which says whether something is materially prejudicial shall be determined by the trustee in its sole and absolute discretion, which kind of gives it a huge amount of leeway to decide what is material and what is not. But despite that formula, I think most lawyers advising would say, these things you need to have very good reason to change, otherwise you're running the risk of a breach of trust, and that's a pretty serious allegation. Okay, next we go on to what somebody raised earlier, the applicability of the fiduciary duties applicable to any trustee under common law, or as we say, common law or equity. Now, the trust deed contains your usual standard exclusion clause, which says the trustee shall have only such duties as are expressly set out in the trust deed, and no others. It's the same clause you saw in the agent bank clauses in a syndicated loan. No duties other than those expressly set out in the trust deed. But it doesn't stop there. The trust deed clauses then pull out each one of the duties imposed by the law on any trustee and starts ripping them out, terminating or eliminating it. Starting with the obvious one, the duty to act with due care, skill, and diligence. Now, in a 1980 case involving Barclays Bank Trust, the court said this is a fundamental duty of a trustee and must be carried out with the strictest of diligence. But what happens in the international bond trust deed is not just a negation of the duty of due care, skill, and diligence, but to negate it in very specific circumstances. Starting with, the trustee shall have no duty to monitor compliance of the bond covenants by the issuer. That obligation which would arise under common law is abrogated. 2, the obligation to consult with bondholders and have bondholder meetings to decide what should be done in certain circumstances. Normal common law duty, abrogated by a specific clause. 3, the general obligation under the common law that a trustee must keep the beneficiaries properly informed. In this case, that means the bondholders. An express clause says the trustee has no obligation to keep the bondholders informed in any way about anything about the trust or the bond issue. Next one. Trustee should not act in cases where material prejudice to the bondholders occurs. Now that has not been abrogated, but whether material prejudice does or does not exist is made subject to the final and conclusive determination of the trustee. Note the phrase final and conclusive determination, i.e. it cannot be questioned. So while there is an obligation not to cause material prejudice to the bondholders by the trustee's actions, if it decides, no, there is no material prejudice to the bondholders in what I'm doing, that's final and conclusive under the terms of the trust deed. Now that is not to say, and I think any lawyer in the global markets advising on this, most of us, would have said, yes, you've got a final and conclusive determination clause, but don't believe that a court looking at it will not overturn it and say, yes, we the courts have a power to review this final and conclusive determination. So it is there, and the trustee does have the protection of this clause, but one wouldn't simply say, yeah, therefore you're fine, because of the potential override of review by a court looking at what is essentially a fiduciary trustee whose duties have all been taken away. Next, trustee's duty not to allow its duty to conflict with its interests. Same old story as in agent bank. Once again, express clauses enable the trustee to act in the face of conflicts of interest. Remember that formula? It's the same formula. May enter into any financial transactions with the issuer, enter into any business engagements with arrangements with the issuer, make whatever profits you need or want with the issuer, and you will have no obligation to account to the bondholders. It's the same formula, same clause. And it makes perfect sense when you sit back and say, well, who are these trustees? They're not individuals. They're not even corporate trustees. They are all trustee divisions of the global banks. Deutsche Bank trustees, Barclays Bank trustees, Citibank trustees, JP Morgan trustees, and the like. Therefore, it would be crazy to say you can't have conflicts with your interests and duties because JP Morgan had to stop working. Consequently, you have this very powerful clause, very similar, if not identical, with the clause that you saw in SLAs with regard to the powers and duties of an agent bank and the exemption provisions that give protection to an agent bank. It's pretty much the same. Thirdly, any duty that the trustee has to make any information disclosure to bondholders of the occurrence of any material events which it becomes aware of, which is a duty which would arise in a normal trust deed, has once again been abrogated by a specific clause which says the trustee shall have no duty to make any disclosure to the bondholders with regard to the occurrence of any events which are material to the bond or the bondholders. Abrogated again. Does that answer the question that you kind of raised?
Yes, it answers, but
Oh, there's a but to it, okay.
but is that still, if I take like a huge amount of money, like
Run again slowly.
if I am a trustee and
Who's you when you say I employ a trustee? You don't employ a trustee, the issuer appoints a trustee.
yes.
Okay?
So if issuer appointed a trustee and the issuer goes into default, like knows that it goes into default, and the trustee has the only power to call this default or accelerate this bonds. And it offers money or some kind of favor, and trustee doesn't do anything, doesn't take any action. So I'm a bond.
Liability for negligence can and is excluded in those clauses that we talked about.
No, it's
But what it cannot exclude, and this is the ruling of the court, the highest court, that you cannot exclude the obligation to act in good faith as a trustee. So the good faith provision is actually there. You can't get away from it. Despite all those clauses, Consequently, if you do what you suggested, i.e. take money from the issuer and fail to act, you're liable. Dundee Hospitals and Walker. The next one that you need to think about is this, that there's an LMA clause which you've probably come across before. This idea of restricting liability to willful misconduct and gross negligence. Now, if that clause is used, meaning in relation to a bond trustee, and it is sometimes used, the trustee's liability shall be restricted to willful misconduct and gross negligence. Any attempt to include any other duties would not be possible because of the fact that a specific duty has been created by the trust deed clause saying that the trustee has a duty not to engage in willful misconduct or gross negligence. If that clause is there, the court said, well, you can't import anything else. That's it. This was decided in 2013 in the Royal Bank of Canada ruling. So that gives you a rough understanding of where the law is in this area, in this rather gray area, where you're dealing, and I'm going to try and explain this in the context of trust law, because I know you haven't done, many of you haven't done trust law. The attempt to reduce the obligations and duties of a trustee to a minimum is driven once again by insurance. Because if a trustee had liability, Deutsche Bank trustees would want insurance to cover any liability that it might arise. Thus, in order to reduce insurance premiums and thereby the cost of a bond, you have these extremely broad exemption clauses. That's the commercial side of it. The legal side is how far can you reduce the duties of a trustee under the common law? Can you reduce it to zero? I think most lawyers, both professional and academic, will say no, you can't. Because if that happens, there is no trustee. The trustee must have some kind of duty. And that requirement, that the trustee must have some kind of duty, is satisfied by one of two things. One, the duty to act in good faith, which is the one we talked about earlier. And two, some law firms use this phrase, trustee must not act with gross negligence and shall not engage in willful misconduct. That imposes a duty, and most law firms will give an opinion saying that's enough. That's a duty on the trustee, and that satisfies the requirement that a trustee must have some duties, and it's there. So that's where the sort of technical legal stuff lies in relation to trustees in international bond issues. What I want to get on to before I move on is the question that somebody asked me here, why do we have one of these bond trustees? And the reasons are, I mean, mostly commercial, but very importantly, it is that these trustees are professional entities. These are not people plucked off the street. This is Deutsche Bank trustees, this is JP Morgan trustees, this is Royal Bank of Canada trustees, and so on. They are professional organizations, usually a subsidiary of a major global bank. And therefore, there is a single professional organization which can act on behalf of the bondholders and deal with the issuer. No duty to do so, but it's got the power to do it. Secondly, default. Instead of leaving the whole question of default and negotiating a rescheduling or a restructuring to a myriad of bondholders, account holders, you have one professional organization to decide what should be done in the face of a default. Should you call a default? Should you accelerate the bonds? All those decisions are left to a single professional organization rather than have endless resolutions by bondholders, which is what would happen if you had a collective action clause under a fiscal agency agreement. This makes rescheduling and restructuring one heck of a lot easier if you've got a trustee, because the entire restructuring will be handled by this single professional organization on behalf of the bondholders. Next, in the event of a restructuring which is bordering on an insolvency, a trustee, remember, it can hold a property, it can own property. is able to take asset security from an issuer for the benefit of bondholders and hold the assets for the bondholders as security trustee. That can't happen in the case of a collective action clause procedure. The only way is if you've got a CAC structure and the issuer goes into default and near insolvency, if you want to take security, the only way to do it is to appoint an agent and enable the agent to hold the property, the asset which is the subject of the security. You can't go beyond that. And that exposes it to a lot more problems because in the case of a trustee holding property, while it has the legal title, the beneficial proprietary title is with the bondholders. That makes a huge difference to the property rights. Next, the trustee, as you remember, has no duty whatsoever to monitor compliance by the borrower of bond covenants. That's the legal position. The real life practical position is that while a trustee does not, a trustee corporation in other words, does not have the legal obligation to monitor compliance, in practice they do. What they don't want is a legal liability for not monitoring. And therefore, while if you look at simply the legal document, it means, oh, this trustee doesn't have to go monitoring. In fact, because these are highly reputable, highly respected organizations, they do monitor compliance without a legal obligation to do so. Next comes the question of calling of default by the trustee, followed by acceleration and enforcement action in court, if that's necessary. Now, if you got that, if you don't have a trustee, bondholders will have to institute proceedings themselves. And then you've got the multiple bondholder problem, meaning different bondholders will bring different actions in court. Whereas if you've got a trustee, there'll be one single action. That's important for one more reason, cost. Multiple actions means multiple cost. Trustee, single cost, single court litigation. So therefore, there are a huge number of advantages of appointing a trustee. And as I said, the real reason why more bond issues are not subject to a trust deed is simply the unfamiliarity of the bond investor market with this thing, this odd common law thing called a trustee. And that's the reason for it. Otherwise, I mean, most law firms would say, I think it would be a good idea to appoint a trustee. Yep.
Doesn't appointing a trustee be quite expensive for the bondholders?
Thank you. It's absolutely right. That is absolutely right. The appointment of a trustee does involve greater costs than a CAC procedure. And that is also one more reason why issuers are not happy about appointing trustees, because they've got an annual cost to pay fees to the trustee. So absolutely yes. That's also a dampener in terms of taking on more costs in relation to the bond issue. And an ongoing basis, not an initial cost, it's an ongoing cost. So you're absolutely right in making that point. Great. Any other questions, or are we done on this area? What I'm going to get on to, sorry, yeah.
Does the trustee also have the right to ask for a no default certificate?
Yes, of course, as I said earlier. Asking for no default certificates, asking for financial reports on account, all of that is within its powers. The no default certificate, which is required to be given automatically, is the one at the end of the annual report. Sorry, not at the end of the annual report, at the end of an annual accounting year when the annual report is produced. And then a no default certificate must be produced without the trustee asking for it. Yeah. You asking me whether bondholders must accept whatever the trustee and the issuer agree with regard to restructuring? Sorry, you need to speak up. answer no. If the bondholders do not like what they are seeing, don't forget they've got the extraordinary general resolution power, whereby they can pass a resolution requiring the bond trustee to take action or not to take action. There is a right to override with a 2/3 majority vote. So if restructuring agreed between the issuer and the trustee is unacceptable to 2/3 majority of bondholders, then of course they will override it. But in practice, let me give you the practical side as well. A trustee entering into a restructuring with a defaulting issuer won't agree anything finally with the issuer unless it goes to the bondholders and requires them to pass an extraordinary general resolution saying, I agree with the trustee's proposal. Clear and you're home and dry. Otherwise, you are open to exactly what I've just said, the extraordinary general resolution procedure whereby the bondholders can override the decision of the trustee with a 2/3 bondholder vote. Yeah? Can the issuer who? No, I mean, I think that the only thing that the issuer will know is that the bondholders are account holders in the 3 clearance systems. If it wants to send a notification to its bondholders, it sends it to the clearance systems and say, to my bondholders, Happy Christmas or whatever. And then the clearance systems will distribute the notification. Well, the important point is, if you remember, all bond issues are done on a bearer bond basis. Even though the bonds are not transferred, they are bearer bonds with no registration numbers recorded against each buyer. None. All you have is a fungible amount of bonds credited to the account of a bond purchaser in the clearance systems and then down the chain. There's no registration numbers against each buyer. So there's no way of tracing who's bought it, except via the books of Euroclear, Clearstream, and DTC. Any other thoughts, comments, etc.? What I thought I might do next week, now that we've gone through the basic bond documentation, including the terms of the bond instrument, I thought there was one document which I didn't walk you through, and that's the bond prospectus. The reason I didn't walk you through that is that it is subject to regulatory law. Everything in that bond prospectus comes straight out of regulatory law. And in practice, that's EU regulatory law. Why? Why not US regulatory law? Because the entire international bond markets operate, once again, within an exemption to United States securities laws, which exempts them from filing a similar document with the US Securities and Exchange Commission, which I will come to when we talk about US securities laws. Consequently, I will deal with what is in the bond prospectus under EU law. My only hesitation about dealing with it without dealing with regulatory law is that the bond prospectus, obviously, as you might have guessed, gives rise to liability if there are false statements, omissions, etc. And what law controls liability for all of that is a matter, once again, controlled by regulatory law. So I'm going to have to go into some depth on the regulatory law if I'm going to acquaint you with what's the bond prospectus, what does it look like, and so on. There's one other problem for you guys, and it is this. You're right on the cusp of a change in the regulatory regime. We're at the moment operating under the EU Prospectus Directive, operational into 2019. Somewhere in 2019, the EU Prospectus Regulation supersedes the EU Prospectus Directive. Okay, before you get, oh my God. The rules in the Prospectus Regulation are nearly the same as those in the Prospectus Directive. So what I thought I'd do, for this year anyway, is to take you through the prospectus directive, because that is the law, and then take you into the prospectus regulation, which allegedly, hopefully, will come into force somewhere in 2019. We don't know when. Yeah.
But won't the prospectus rules update on a yearly basis?
It's not the prospectus rules, it's the prospectus itself which will be updated. Anything else, or can I get a 10-minute break before my next seminar? I think we're making good progress. I mean, gosh, we actually got through this, but I mean, the next area is, I mean, after we do one prospectus, becomes seriously heavy going. I warn you in advance. United States securities laws. I'm going to try and talk about it as briefly as I can, bearing in mind that if you go to a US law school, you do a whole year on United States securities laws. Luckily for us, all that we are concerned with is that bit which affects the international global markets and nothing else. Okay, we're done, guys. We'll see you next week. Did you send me the attendance lists? Give me a second, I'll just get rid of this stuff. Give me a second. All right, fire away. Who wants to go first? I'm sorry? The room for this seminar, the Wednesday seminar. It's the second basement in the Somerset House East Wing building, where the law school is. Hang on. Did you look up the timetable? Okay. SW 2.17. Somerset House. It's the shortened form for SHEW, Somerset House East Wing. Yeah. Okay.
I did it yesterday, but I think like on Monday.
Are you on in the Monday group, or which group are you in?
I'm in the Monday group.
Okay.
but-
A or B?
Yeah, but
A or B?
Oh, sorry. I don't remember, but it's 4 to.
God, this is really bad if you don't even know which group you're in, which means you're not doing any work. Okay.
No, I remember the time, but it's A or B. It's 4 to 6 p.m. So I didn't attend it on Monday, but I know to you.
Did you attend it on Tuesday?
Yeah, I did it
Okay.
yesterday, but
Okay.
I didn't ask and tell you like to take
That's
my
fine.
name.
Can you go back to the Monday group from next week?
Yeah, sure.
Fine.
But I think like on the list, my name is like you didn't take it.
That's okay. We'll do that when you're there next week.
Okay, so I will tell you again.
Please.
Okay.
Thanks. The attendance lists
New one.
for this semester. Were you going to do those?
Yeah, of course.
We're already second week. I need to mark the attendance
Like,
list.
I can now print it, but you told me that there are changes as well.
No, the same ones. You remember the people who came to you?
Four people.
Yeah. Let me
I
just.
already changed it. And I
Oh, you
sent
changed those. Okay, wait.
I just have to
Let me just see who else.
print
Okay.
it.
I mean, people keep writing. I mean, this person said, I'm in the Monday group. I couldn't attend. I didn't attend the Tuesday group. How am I going to go? And I thought, what the hell? You don't even know which bloody group you're in. Anyway.
The changes already.
I mean, I know it's it's just hopeless. Where is this bloody list? Okay, there it is. This is what I did was I just marked the presents on
Here?
the last semester lists. So what I'll do that today as well, but then I think I'm going to have to input it for.
If there is no, yeah, I think it's I don't remember them to asking me.
Oh no, that's Wednesday, the A group.
Yeah.
Today is the B group. I don't even have a printout for them.
Uh,
So what I'm doing.
Yeah. New ones I will print, but if there is no change, if they're changing, I will input.
That's okay. Just yeah. If you have time, otherwise don't worry. I'll do it.
No, I'll
You sure?
go up here before coming to the lecture, and I will just print it because I have.
Are you doing a seminar with me now?
Yeah.
Oh, okay.
I missed that last one.
Yes, I forgot about that.
Yeah.
Okay,
Yeah,
great.
okay.
All right, I'll see you.
Yeah, I'll join you at the seminar.
I haven't yet drunk that bottle of wine, but I will.
What?
I said I haven't yet drunk your bottle of
Yeah,
wine.
but
I will.
it's semi-sweet, but I'm not so sure that you like semi-sweet.
I'll tell you.
Yeah, but it's kind of
But
traditional.
what's the other one?
The other one is, I texted you, it's called Chuchela. It's kind of made of juice of grapes and walnuts
I
inside.
thought it was. I looked at it and I thought, it's a sausage. Then I thought, no, it's not a
No,
sausage. It doesn't smell like meat at all.
So you should take this thread there's inside, so
Yeah.
they are drying this.
So you cut it.
Yeah, so then we cut it because it's quite hard to eat like this.
Oh,
I eat like this, but like normal people don't just cut
So
it.
it's kind of dessert.
Yeah, it's kind of dessert. It's sweet and it's healthy. Just I told you that it has walnuts, so
Okay.
people used to
Okay.
have-
I know if you've got nut
Yeah.
problems.
So it has walnuts in it, and it's kind of like I like it. So it's traditional. It's called chuchela.
Good. Thank you. I'll try it and let tell you what I think.
I'll see you in 10
Yeah,
minutes
okay.
before I will print it out. Yeah.
Hi.
Do we have class during the reading?
No. I think I told everybody no classes.
Because in the timetable isn't there.
Oh, I see. Okay, I'll tell. Please give me a reminder. I'll tell everybody next week. Okay.
Thank you so much.
All right.